This time, I will turn the floor over to the attorney for the district for your presentation.
Representatives of NDOT and members of the public, I want to first thank everybody for coming back from lunch today. Gives me hope for our side of the discussion. My name is David Lean. I work at Graves, Doherty, Heron, and Moody, a law firm in Austin, and I represent the Lost Pines Groundwater Conservation District. On behalf of all of the districts, I'm going to give a brief overview of our side of the discussion. I have given to NDOT, and I have given to the court reporter, and Mr. Reynolds, I've given to you a notebook. In that notebook, you'll find a handful of things. First, you will find our written response. I encourage you to read it. I hope you will. We worked hard on it. It contains much argument and references to much evidence that refute much of what you heard this morning, and which I may not be able to touch on today. It contains a handful of affidavits labeled Exhibits A through E, each of which has exhibits attached to them. And this not being a regular evidentiary proceeding, I don't know quite what to say, but I would ask that those be considered as evidence by the board in making its determination. After I'm done speaking, John Seifert, who is a hydrologist and who is a consulting hydrologist during the DFC process, will give a presentation. And as compared with me, he is the person who will know what he is talking about. And he will talk about, in the main, the science that went into the determination of these DFCs. We've heard today that no science went into the determination of these DFCs. That is manifestly untrue, as will be clear after Mr. Seifert's presentation is finished today. After Mr. Seifert presents, you'll hear from Gary Westbrook, who is the general manager of the Post Oak Savannah Groundwater Conservation District. He will talk about, oh, I apologize. That's right. He is not going to speak. I apologize. I was recently reminded. That is, after Mr. Seifert, you'll hear from Monique Norman, who is who's the lawyer for 2 of the Groundwater Conservation Districts, and she will conclude our presentation. The first thing I want to say is that I appreciate Mr. Thornhill's comment that this is not a personal problem that NDOT has with the groundwater management, the districts in the GMA. And we appreciate hearing that. My client, the Lost Pines Groundwater Conservation District, and the members of the board, would not want me to defend them. But I'm going to defy their wishes for just a moment. There were certain comments that I heard this morning, maybe you heard them too, that indicated that at the very least Lost Pines has a personal vendetta against NDOT and personally wishes to see that project fail. Nothing could be further from the truth. What you will find, particularly as we present today, and those of you who know the people who serve on these boards already know, is that these are hard-working, largely volunteer people, giving hundreds of hours of their own time that could be spent with their own families, but giving hundreds of hours of their own time in meeting and in study to make sure that they get this process right. And the evidence that we will show today, that we will present today, will make it very clear that they did get this process right, and that they deserve a claim, not that they seek it, for the job that they did. A few facts you may already know. GMA 12 is comprised of 5 districts, and it stretches a very long way. The Brazos Valley Groundwater Conservation District, Fayette County Groundwater Conservation District, the Lost Pines Groundwater Conservation District, the Mid-East Texas Groundwater Conservation District, and the Post Oak Savannah Groundwater Conservation District, which was kind enough to host us today. We are speaking a lot about the DFCs themselves today, and the DFCs while the most important thing that we will discuss today, were just the culmination of a long, long process. These districts didn't wake up one morning and determine what the DFCs would be. Rather, they took part in a 5-year process, starting in December of 2005 and going to August of 2010, holding 13 joint meetings of all 5 districts. Contrary to what you may have understood from this morning's presentation, they heard a tremendous amount of input from stakeholders, many of whom are in the room today, I'm sure. The DFCs themselves were submitted to the Water Development Board in August of 2010, at the end of this 5-year process. And the Water Development Board accepted those DFCs, finding that they are quantified and physically possible. If you want to read more, I'll talk more about it, but if you want to read more about the process, particularly in these joint meetings, I encourage you to have a look at Gary Westbrook's affidavit, which will be presented. Has it already been tendered? Which will be tendered before the day is out today. It attaches minutes from all of the meetings, and it attaches a number of presentations made by stakeholders, including NDOT, which I will go into in greater detail today. Now, as I say, they heard a great deal of stakeholder input. This stakeholder input came from a wide variety of stakeholders, such as environmental groups, environmental stewardship, for example, who you'll hear more from next week because they have their own petition, from the Environmental Defense Fund, from the Sierra Club. GMA also heard from a number of local government stakeholders, Brazos County, Milam County, Roberson County, Burlieson County, the city of Bastrop, the city of Rockdale, the cities of Bryan and College Station, together with Texas A&M University, who presented particularly on the socioeconomic impact of withdrawal of water from the GMA. You'll also find, as you look through the minutes, that the GMA heard from landowners and state agencies, including the Texas Parks and Wildlife Department, and indeed the Texas Water Development Board, as well as the Brazos River Authority. And they heard from stakeholders like NDOT, water marketers, Metropolitan Water Company, Southwest Milam, Blue Water System, Brazos Valley Water Alliance, Milano, Water Texas, Aqua Water, and again, our petitioner today, NDOT. All made presentations and all provided input to the GMA, all of which was considered. Now, the process didn't just take place in joint sessions between the 5 districts. It also took place in the individual districts themselves. For example, Lost Pines itself held 31 meetings between January 2008 and July 2010 during the DFC process, and itself heard a great deal of stakeholder input regarding the DFC process. They got that input from environmental stewardship, again, next week's petitioner, the Environmental Defense Fund, Aqua Water Supply, the Texas Parks and Wildlife Department, the Texas Water Development Board, and again, today's petitioner, NDOT. All of these stakeholders provided input to Lost Pines Groundwater Conservation District, and all of that input was properly considered. I believe you'll find that the other districts similarly solicited, received, and considered stakeholder input. Now, it's possible that I misheard, but I believe that I heard the petitioner this morning say that the burden is on the districts to show that the DFCs are reasonable. The districts are not afraid of such a burden, and the districts are prepared today to show that that is the case, but I believe that that is an improper statement of the burden in today's proceedings. Rather, the burden is on NDOT, the petitioner, to show that these DFCs are unreasonable, and that's a burden that they did not carry this morning, as we are prepared to show this afternoon. So if I did not say another word, if Mr. Seifert did not present today, it would still be within the Water Development Board's power to find that NDOT has not met its burden and that its petition should be dismissed. Unfortunately for all of you, I am going to continue speaking. Mr. Seifert is going to present, and we'll be here for another hour or two. The districts did what the statute requires of them. And we're going to walk through how they did what they did and the things that the statute requires of them, and discuss just for a moment how they did what the statute requires of them. Section 36.108D of the Water Code requires that the districts consider groundwater availability models and other data or information for the management area. I'm going to leave the bulk of that information as to how the districts did so to Mr. Cipher, and he'll testify that the districts worked with the Water Development Board using the appropriate GAM for the region to help develop the DFCs. So the districts met that requirement. Section 36.108D goes on to require that the districts consider uses or conditions of an aquifer within the management area that differs substantially from one geographic area to another. I did not hear much of this morning, but I did read it in the petition. The suggestion that there is a single average drawdown that was chosen as a desired future condition applied to the entire GMA. Mr. Thornhill is shaking his head. He knows better. That is not what we did. Rather, the districts adopted DFCs within each district that considered the uses or aquifer conditions peculiar to the individual districts and the individual geographic areas. So the districts met this requirement. Now, under the then applicable law, that's what the districts were required to do, and they did. As the Water Development Board reviews the DFCs now, there are other things that the Water Development Board itself is required to consider. First, whether the DFCs are physically possible and whether consideration was given to groundwater use. The DFCs are physically possible. The Water Development Board itself found so when it approved them. And groundwater use was considered, painstakingly considered. The districts painstakingly considered existing use, projected demand under regional plans, as well as the state water plan. The Water Development Board will then, in its review, consider whether the socioeconomic impacts reasonably expected to occur as a result of the DFCs. Again, stakeholder input was considered, including the impact on existing users, including the cities of Bryan and College Station and Texas A&M. And the reason that I mention those is not simply to curry favor with Aggies, but because we have submitted, as an example of stakeholder input received on this issue, a PowerPoint presentation made by the engineering firm HDR on behalf of the cities of Bryan and College Station, as well as Texas A&M. I believe it's attached as Exhibit 3. I apologize. Exhibit 4 to the affidavit of Joe Cooper, which is Exhibit C in your notebook. And so the DFCs meet that requirement. In your review, you will also consider the environmental impacts, including but not limited to impacts to spring flow or other interaction between groundwater and surface water. This, I don't believe, is one of the grounds stated by the petitioner in this proceeding, but I imagine it will be the subject of much discussion next week's proceeding. GMA 12 did consider this factor and did consider requests to use stream and spring flow as DFCs, but did not use them due to the complexities associated with the metrics and due to the fact that they had difficulty getting sufficiently reliable data in order to use them. And you consider the state's policy and legislative directives. GMA 12 incorporated the regional and state water plans then in effect, as well as information from those plans at the time, as well as the requirements of Chapter 36. And though, of course, in 2010, the 2012 state water plan was not yet in existence, the DFCs, as currently constituted, are consistent with the 2012 state water plan. And so the districts met that requirement.